Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 20-1503 et al. Sierra Club petitioner versus United States Department of Energy. Ms. Naismith for the petitioner, Mr. Smeltzer for the respondent, Mr. Nelson for the interveners.
Good morning, Your Honors. May it please the court, Manine Naismith for petitioners. I've reserved 5 minutes for rebuttal. The question before the court today is narrow. Once DOE decided to conduct additional analysis on rehearing, did DOE carry out that analysis arbitrarily, and did it sufficiently explain its new conclusions? I'd like to focus primarily today on the problems that arise from DOE's failure to clearly explain what conclusion it reached as to the project's climate harms, how those harms factored into its decision to approve the exports, as well as DOE's uneven handling of harms and benefits. In order to assess potential climate harms, DOE conducted a study that held multiple variables constant and focused primarily on the effect that market substitution would have on possible climate harms. At one end of the spectrum, DOE assumed that all of the gas exported from Alaska LNG would substitute for gas that would have otherwise been produced in the lower 48 states. On the other end of the spectrum, DOE assumed that all of the gas produced by Alaska LNG would be additive to global LNG markets. Based on those two extremes, DOE calculated two equally extreme amounts of potential greenhouse gas emissions that could result from the project. And at the same time, however, concluded that neither extreme was likely to actually occur. DOE, however, did nothing to try to narrow that gap. It concluded in Order 3643C that, on the one hand, the uncertainty was too great to allow it to reach a definitive conclusion as to climate harms. But then in the following sentence, a sentence that has no analysis, no citation to the record, no explanation, it concluded that in DOE's judgment, the substitution value was likely closer to the perfect substitution end of the spectrum, and therefore that climate harms would not be as bad as at the other extreme.
Ms. Naismith, what is DOE supposed to do if it concludes we're quite confident that there will be economic benefits? We're just not sure whether there will be environmental harms. It's highly speculative.
Your Honor, the problem here is that the uncertainty as to the extent and the nature of those economic benefits exists equally with respect to the substitution problem on each side, and DOE didn't acknowledge that. So they would have to go, the record before this court is that those economic benefits were assessed based not on uncertainty and not on a recognition that, well, we think they're going to be economic benefits, but we don't know how much. This record before the court today has several values ascribed to not an uncertain range of potential substitution, but in fact, a very definitive point that was done by the NERA study of 33%.
Let's get to the NERA study in a second.
Sure.
But I'm just wondering, say it's not this case, but in a hypothetical case, if DOE and its expertise concludes that there will almost certainly be significant economic benefits, and it concludes that there may not be significant environmental harms because the environmental harms are quite speculative. What's DOE supposed to do in that situation?
So in that situation, and again, Your Honor, that's not the record that is before this court, because what they would have to do is if the uncertainty that exists as to the harms also exists as to the benefits, they'd have to grapple with that. And they'd have to come out, they might come out the other side saying, we're not really sure what the net GDP effect of this is going to be. We're not really sure whether we're just shifting jobs from Louisiana and Texas to Alaska.
You're still fighting the hypothetical a little bit. I mean, I get that they would have to grapple with it and explain, but
Yes.
it seems, especially with the Natural Gas Act's presumption in favor of gas, that if there are going to be economic benefits and if it's merely speculative whether there will be environmental harms, that DOE in that situation at least may authorize the export. Is that fair?
If the record truly grappled with the issues that did not.
If it's reasonably explained.
If it is reasonably explained.
Okay. And now let me go to where I think you want to go, which is the NERA economic data.
Yes.
And I see how that makes the environmental harms. I see that if you don't trust that data, it makes the environmental harms highly speculative. There's this wide range. Maybe it's going to drastically increase greenhouse gases. Maybe it's going to actually improve the greenhouse gas situation. Those are the two extremes. But I don't see how the NERA data makes the economic benefit equally speculative or speculative at all, at least in terms of whether there will be significant economic data. And here's why, and then you can tell me why I think I'm wrong. If we don't know the foreign market substitution effect, if that foreign market substitution effect is highly speculative, it seems like there's still going to be significant economic benefits, whether it's a large effect or a small effect. Because if the foreign market substitution effect is high, then it's going to mean a lot more domestic gas, which will drive down gas prices for Americans. That's a significant economic benefit. And if the foreign market substitution is low, then it means we're going to have a lot more exports. And that itself, trade balance and security for our allies, is a significant benefit. So the NERA data doesn't cast doubt on whether there will be significant economic benefit. It's going to be benefit either way. It does cast doubt, if to the extent it's speculative and we can't rely on it, that would cast doubt on whether we can know whether the environmental effects will be significant or not. Because if the NERA data is unreliable, then we've got this wild range and we're not sure exactly where we should be.
So a few responses to that to unpack some of what Your Honor just said. So first of all, the extent of substitution that DOE looked at here was the extent to which gas from the lower 48 states would substitute for gas from Alaska LNG. And while it is possible that gas from other parts of the world could substitute, the specific climate numbers that DOE came up with here were predicated on not is the gas going to come from Qatar, but is the gas going to come from Louisiana or Texas? The numbers that they came up with, the analysis they chose to do here, what we have in the record is there is a climate benefit to not having to schlep gas from Louisiana and Texas all the way to Asia. We have to take that as the given here, even though there are other potential uncertainties that weren't really referenced as the centerpiece of this climate analysis that DOE opted to do. So when we are looking at that substitution effect, there is a potential for a pretty different economic benefits picture depending on where you are in the extent of the substitution, because there is not necessarily any net benefit to GDP if the gas would have been produced anyway. There is not necessarily any net job creation if the gas would have been produced anyway. And the economic picture DOE would have had to grapple with in its order, not to say there's no benefit at all, but the picture is very different. And at that point, DOE is essentially picking and choosing amongst regional winners and losers.
I guess I take it that DOE was using the lower 48 as a proxy for the foreign market substitution. But I don't understand how if the end result is a lot more gas in the United States, not leaving the United States, it just seems like if supply is greatly increased, then prices are going to go down.
That's not actually necessarily true, Your Honor, and this starts to get beyond what's in the record, but actually greater exports have been shown to drastically increase consumer prices. at home.
But
I want to ask you, if I may, about the idea that environmental harm is speculative. Let me just see whether you agree with this. I'm getting these numbers from the Undersecretary of Energy in charge of science during the Obama administration, that the Earth's atmosphere consists of mainly of nitrogen and oxygen. You agree with that, right? That makes up 99% of the Earth's atmosphere. The rest of 1% is mostly argon, which is inert gas. Among the remainder, the largest greenhouse gas is water vapor. And that leaves 0.00001 for carbon dioxide, which is what you're worried about. And we're talking about the entire world, not just a port in Alaska. So how can it, I mean, it seems to me absolutely impossible, if those numbers are correct, and they are, I think they are, that any kind of a burning of the gas coming out of Prudhoe Bay is going to have even the slightest wrinkle of an effect on global climate. Now, where is Mr. Coonan, the Undersecretary, wrong about that?
Well, Your Honor, I can't speak to the specific data you gave in
You
terms of
talk
the
about harm.
the harm.
What is the harm?
So the harm is that global warming and climate change is a quintessential collective action problem. It is not the case that any one actor by themselves is ever going to be responsible for either tipping the balance one way or the other in terms of causing all of climate change or solving all of climate change. But what we have to do to solve climate change, what every climate scientist with adequate credentials has said we have to do, is to stop.
Mr. Coonan is a professor at Caltech now. He also is the head of 3 or 4 of the most prestigious scientific organizations on the planet. Is he a credible scientist? Because he doesn't agree with what you just said.
Your Honor, I can't speak to the credibility of one person. I can say that the vast.
He has 300 peer review papers. Is that enough?
I can't answer that question, Your Honor. I'm sorry, but the vast amount of climate opinions with respect to what we have to do to address the calamity that is climate change is to stop emitting carbon dioxide and methane. And this project would be responsible for millions of tons of carbon dioxide as well as methane leakage.
I understand, and you're here representing, among other groups, Sierra Club, even though you're Earth Justice. Is that okay? So I understand that a Sierra Club goal is to reduce greenhouse gases, and I understand. Let's assume, for the sake of argument, that by prevailing in this suit, you would succeed in reducing greenhouse gases, and therefore, further your one of your organization's missions. It seems like the Natural Gas Act is an odd vehicle to do that, because Sierra Club wants no expansion of natural gas. They want no additional exports of natural gas. And it's all over their website. Just to give one quote, Sierra Club is working across communities to stop the expansion of the oil and gas industry. You can click a link. It will write your member of Congress and tell them how terrible it is that natural gas is being exported. But the statute that you've chosen as your vehicle to challenge this project is a statute that presumes export of natural gas. Our court has said it creates a presumption in favor of exports. So it just seems like, if you were doing a Clean Air Act suit, I get how that may or may not be a good vehicle depending on the particular case. But it just seems like in almost every case, and maybe every case about exports, if your goal is to just not have exports, the NGA is a really odd vehicle to try to accomplish that.
Your Honor, the Natural Gas Act does not say that all exports should be approved. It gives DOE responsibility for
But it
exercising.
does assume that some will be approved.
Yes.
And you don't want any approved.
At this point, Your Honor, DOE has never said no to any exports. It would be, what we are seeking in this case is for DOE to comply with the Administrative Procedures Act, the National Environmental Policy Act, and the Natural Gas Act to
And I-
provide a coherent record and explain the basis of its decision. And it has not done that here.
And Ms. Naismith, I'm not blaming you for this, what I view as sort of tension between the NGA as a vehicle and the goal of the suit. But I do wonder, what would it take for an export of natural gas project to be legal under the NGA, according to you?
We could start with an accurate and clear underlying record in which DOE adequately assessed the harms on the one side and the benefits of the other.
And has that ever happened in the past 10 years, 15 years?
I can't speak to every single record that's out there, Your Honor.
Can you point to a single under the Obama, Trump, Biden administrations? Can you point to a single natural gas export project that you think was legal under the NGA?
Again, Your Honor, there are too many for me to be able to answer that question. I can say in this case that underlying analysis and explanation of what did DOE look at? Did it in fact look at the underlying, did it look at the underlying data and record in an arbitrary fashion? Here again, you have an order that says on the one hand, here are two extremes. We don't think either extreme is right. We're not going to bother to try to get to a number that's right. We're going to say on the one hand that there's uncertainty, so we can't come to a conclusion, but then in the next sentence, we're going to say, oh, but in our judgment, we think it's closer to the perfect substitution side of the spectrum, which leaves anyone in the public, no matter what their aim, completely unclear as to what this decision really was and how DOE got there. And irrespective of what...
One
Yes,
of the
Your Honor.
things DOE says on the point you were just raising is that there is a fairly extensive analysis of market factors and reasons why LNG might cause substitution or not in the target export countries. And they call that their qualitative analysis. What's your
So the response to that is, Your Honor, that most of that's in the brief. It's not actually in the underlying order.
No, I think there's about 5 pages of it in the SEIS about market conditions in Japan, China, et cetera, et cetera.
Yes, but the SEIS does not come to the same conclusion or come even close to the same conclusion as in the order. The SEIS expressly does not say what the order says, which is we think it's closer to one side versus the other. And that it's telling because the order doesn't cite back to the SEIS at all in drawing that conclusion. And the attempts to explain that conclusion in the order, at least in the briefs, is also telling in that it points to a whole bunch of things, including, for example, the policy statement on export authorization extensions that the brief tries to use as a basis for bolstering that conclusion, that in fact the order 3643D says, well, no, that policy statement's not relevant here. So there isn't a clear explanation of, again, trying to say, this is extreme. We don't think either end of the spectrum is correct. Let's try to narrow it down. And if they do truly think that it's closer to the end of the perfect substitution, then explain that. Say that clearly in the order, and then explain why in a situation, and then to go to the, I realize I'm very much over time, but to go to then the imbalance problem is if that's the side of the spectrum that DOE thinks we're on, that's not the side of the spectrum that the benefits analysis was done on. The side of the spectrum the benefits analysis was done on was the other end of the spectrum, where there would be much higher climate harms than what DOE seems to be thinking is likely here. So you have this incredibly unbalanced, muddled record, which fundamentally leads to the inability of the public or anyone else with an inability to know, well, is DOE thinking that we're closer to one end than the other and that's what's really going on here? Or are they just okay with a decision that where the climate harms could be anything and they're not going to do anything to try to narrow that gap? If the uncertainty was truly that great, and to go back to Judge Walker, some of what you were raising earlier, what should have happened here is for them to say that without this guessing game of, well, we think it's closer to one side or the other, to say it's too uncertain. We would disagree with that. But if that would be where DOE sits, they could have then also then said, okay, so we're now disavowing the NERA study. We don't think that was accurate for reasons that, again, are not particularly clear in the order and are much more present in the post hoc rationalizations of the brief. But to say then, for both sides of the equation, it's too uncertain. So this project could have incredibly high climate harms in a world of additive, but also actually higher economic benefits than what the NERA study even contemplated.
What if I think it's reasonable that the agency concluded that the NERA data is too outdated to be useful? I can see how that, just for the sake of argument, would undermine the economic analysis that they did in the original decision. But that part of the decision, I think, is not before us, wasn't challenged on rehearing by you, isn't something that we can really address here.
It is, Your Honor, for the simple reason that at the time the original rehearing request was filed, we didn't have the benefit of any analysis on the harm side. DOE is the one that opened the door to say, well, everything is so uncertain because of market substitution. That line of reasoning was not in the record at the time the original rehearing request was filed, and therefore Sierra Club and anyone else could not have been in a position to say, well, wait a second, that's not, you're not treating the entire record consistently. If DOE had simply said, for example, we're going to use the NERA numbers, we're going to come up with what we're going to be consistent, we're going to use that number, and here is our climate harms, this would be a completely different case. But they opened the door by how they went about doing the climate harm analysis.
Thank you very much. We'll give you time on rebuttal.
Thank you, Your Honors.
Good morning, Your Honors. May it please the Court, John Smeltzer for the Department of Energy. Your Honors, the Department of Energy took a hard look at all of the environmental impacts in this case, including climate impacts. And they reasonably concluded, based on that hard look, that the environmental impacts did not overcome project benefits and did not outweigh or overcome the presumption in favor of exports. And we think those judgments are entitled to this Court's deference.
Did the original economic decision, economic benefits analysis, depend on the NERA data?
The NERA data was cited as part of the presentation by the project proponent. The analysis wasn't disputed, and so it was part of the conclusion.
Is there an argument that its use, even if it was in hindsight erroneous, was harmless error?
Erroneous use in what context?
Well, imagine that because the NERA data is now so outdated, it doesn't actually inform anything useful. Is there an argument that, well, because it's outdated, perhaps it should not have been in the economic analysis, but it wasn't material even before it was outdated, and so any use was harmless?
Yeah, I think that's a fair way to look at it, Your Honor. I mean, ultimately, the economic determination of economic benefits was not disputed. And what the NERA model showed in general, right, was that there would be an overall net increase in U.S. LNG exports, that Alaska exports wouldn't totally displace exports from the lower 48 states. DOE did not put a precise number on economic benefits, just like with respect to climate impacts. They just made a general determination that there would likely be not a complete displacement, but overall net economic benefits. So I think the NERA model is not disputed. I think Sierra Club essentially agrees that the likelihood is that there would be net increase in exports. And so it was perfectly usable and not disputed for what it was presented for. The key problem with the NERA model for purposes of market substitution is it doesn't address market substitution at all, right? The NERA model addresses the U.S. domestic market and domestic exports. You can model those sorts of things based on certain data that they can be valid for purposes of trying to assess the export market and export demand. But that didn't, the NERA model doesn't go and determine, what is going to happen in the target export markets, what's going to happen in Japan or China or India or South Korea if they import LNG from Alaska. What fuels are they not going to use? Is it going to displace coal? Is it going to displace other LNG? Is it going to displace renewables? All of those determinations in the foreign export markets, right, are going to depend on market conditions in those markets. It's going to depend on technologies, and it's going to depend on economic and environmental policy in those nations, right? Each of those nations is going to determine for itself, how their future economy is going to develop, and those are inherently difficult to predict, right?
The NERA data doesn't inform that.
The NERA data doesn't look at the market substitution in the foreign markets. It just looks at export demand, right?
Is there anywhere in the record that we could look to where DOE said the things that you just said?
Well, the NERA model's in the record, right?
Correct.
And you can, it's cited in our brief, you can see it, and it's in the joint appendix, so you can look at it. DOE, when they were proffered the NERA model, they said that the overall data is out of date, and they also said that it didn't meet the burden, right? It didn't improve the problem, right? DOD defined the problem as needing data on market substitution in foreign markets. You can look at the model, it doesn't have that, and DOE specifically said when it was proffered that it didn't arise to the level, it didn't make this more accurate, it didn't solve the problem of the inherent uncertainty of modeling these sorts of things, right? And that's
So I suppose what they would say in response is the one specific thing in the final rehearing denial is that it's outdated. It's based on a time when the LNG market was far less developed.
yes.
And so we can't basically rely on it for the extent of the economic benefits. And at the same time, when we have the section of the order describing the economic benefits, the only underlying data for that comes from the NERA study. So what's the explanation of why that's not?
Well, again, it wasn't, the economic data wasn't disputed. The idea that there are benefits, and it's not disputed that there's likely to be an overall increase in US LNG exports. The NERA model just gives you a number as to what the projection is going to be.
I appreciate that. And I guess the concern is that when at the end of the order, the DOE says we weighed the acknowledged but uncertain climate impacts against the economic benefits and find that this doesn't outweigh this.
Right.
Now you're telling me they really didn't have in their head anything about the magnitude of the benefits. Well, why is that?
They specifically say in the rehearing order that there are uncertainties on both sides, and they didn't put definite numbers on the economic benefits either. What I think they were getting at is sort of what Judge Walker was discussing, that the uncertainties about substitution effects create much more uncertainties than the uncertainties in relation to economic benefits. What DOE did when it weighed benefits and harms was to assume in both cases that that the project would be built and that all of the exports would happen, right? And then in that context, you're going to get the benefits of trade. You're going to get the economic benefits. What you don't know necessarily is the climate impacts, because you don't know whether the fuel is going to India to replace coal or to Korea to replace LNG from some other market or to replace renewables. But DOE made a considered judgment, right? Ultimately, they looked at they didn't just rest on their two numerical models, right? The models of all the emissions, the greenhouse gas emissions that would cause from the entirety of the project, which they looked at it several ways. They didn't stop there. They didn't stop with the comparison. The comparison helped inform their analysis, of course, by showing that, and it goes to the point of economic benefits, right? If there's no increase in overall US LNG exports and only displacement, you still have a benefit, right, in terms of climate impacts, because it's undisputed in that context, right, that's be lower carbon footprint because of the way carbon or the natural gas is produced in Alaska and the shorter transportation
Yeah.
distance. So that still all supports, right, the overall balancing of the analysis.
Can I also just ask you to directly respond to one of their other major arguments, which is essentially that there's a key finding that we think the climate impacts are likely to be closer to the best case scenario than the worst case scenario, I'm paraphrasing. But they say the rationale for saying it's likely to be closer to the one no action alternative is unexplained. What would you offer in response to that?
Well, I'd say that the analysis is in the record, and it's in the part of the record that Your Honor already pointed to. It's in the life cycle analysis, in the qualitative discussion of markets, and there is an extensive discussion in the record from Joint Appendix 992 to 1000, where it talks about each of the import countries and what their challenges are, and the overall goal of net zero by 2050, and the role that increased natural gas exports can help play in even meeting that target, right? So there's a lot of analysis that shows that there will be a continuing demand for LNG exports. And there is also in the record in that same place, and then also with respect to the policy change in the Federal Register about the export authorization overhang, right? There is indication that the U.S. markets, there's lots of supply either from the lower 48 and in the economic analysis, in the life cycle analysis, they talk about other exporting countries also ramping up supply. So there's reasons to believe, right, that there would be a substitution effect with respect to LNG. And what DOE said qualitatively, though, ultimately, right, is they don't think it's going to be a one-to-one, right? They said it's probably going to substitute, especially over the long term, for a mix of fuels, including renewables and conservation efforts. But what they said is in the near to the medium term, it's most likely to be closer to. But they also said it's most likely to be net negative, right? They didn't put the rosiest picture on this, right? The project was originally proposed as a project that would provide net benefits by the proponent, right? Because it's going to displace coal. DOE didn't make the finding that it would necessarily do that. I mean, there's obviously the opportunity to do that in certain markets, but DOE ultimately, in their qualitative judgment, agreed that it's likely to be net negative. What DOE ultimately determined, though, right, is it was too speculative to determine these things numerically for part of numeric modeling. And this issue has already been addressed by this court. In the Freeport case, which is in the Federal Register at 867 of F3rd 189, right? This court looks specifically at this question of modeling of market substitution effects in foreign markets. And this court looked at it in two places in that ruling, at pages 198 through 199 and at page 202. And on page 202, this court specifically responded to the argument that DOE had failed in that case to look at the replacement of renewables or market substitution effects with respect to new renewables in foreign markets. And this court specifically affirmed DOE's judgment that it wouldn't, by trying to model those impacts, it didn't have the data that would make that sufficiently reliable. You affirmed DOE's judgment in that regard.
I think there's an argument that it was fine for you to rely on the economic conclusion that you reached before the supplemental environmental impact statement. But assume for the sake of this question that you should have reweighed the economic benefits after you conducted the supplemental environmental impact statement. Is it the case that Sierra Club didn't ask the Department of Energy to reweigh the economic benefits after conducting the supplemental environmental impact statement?
Well, I think their argument, Your Honor, is that we put a thumb on the scale, right? That we didn't look at the benefits in the same, the benefits and the harms in the same way, and looked at the uncertainties differently. I think
but they never asked you to reweigh the analysis for the economic benefits?
No, what they asked is that we go back and use some sort of modeling to do some sort of market substitution modeling for purposes of the climate change analysis.
Right. Any question?
No.
Thank you.
Thank you.
May it please the court, my name is Howard Nelson. I represent Intervenor Alaska Gas Line Development Corporation, which is a public corporation of the state of Alaska. Now, petitioners say that uncertainty of harms and benefits exist equally. Well, these uncertainties that they discuss in their brief are not the same. The uncertainties with respect to harm stem from this issue of substitutability of fuel and displacement. And they say, well, DOE should have narrowed it down, the specific quantification. Well, that's what the court in Sierra Club, I call it Sierra Club Flex, that's what they said DOE cannot do because it's infeasible and impractical and speculative. Now, on the other hand, the benefits, most of the benefits have nothing to do with the uncertainty of displacement or substitutability. The benefits in terms of regional benefits, employment opportunities, income, increased tax base, security to our nation and to our allies, they have nothing to do with displacement. Those could be quantified, and that's what was done. Now,
Seems like the strongest argument for them would be on the saying GDP will increase. That is based on ideas about substitution, right?
in part, but the GDP also increases, I think. I mean, you have a lot of economic activity that's ongoing as a result of the construction and operation of these facilities. It's a huge benefit to the economy of Alaska. Now, the uncertainty of benefits, their argument is that because there's uncertainty about market need for the project, and therefore uncertainty about whether the project will be built, that's a different uncertainty. Now, that argument, we believe, conflates and confuses DOE's obligations under the NGA and under NEPA. Under Section 3 of the NGA, DOE is obligated to weigh the benefits and burdens of their export authorization if the project is built. Any uncertainty that results from, whether there's market need for the project or whether it will be built is simply not a consideration for DOE under the Natural Gas Act. If the project is not built, there won't be any burdens or benefits. And so with respect to the uncertainty created by market need, that is an obligation. Well, the uncertainty DOE's examination of harm resulting if the project is not built, that stems from the obligation under a duty to examine a no action alternative under NEPA. And under NEPA, there's no obligation to examine benefits at all or to weigh those benefits against harm. So under whichever way you look at it, there's really no balancing an uneven application that has to be done.
Council, your brief has a discussion of the impacts of a vacatur order from this court. Are you able to tell us anything about the current status of the project?
Yes. There have been and there continue to be ongoing discussions with investors to try to get investment for the project and also with offtake customers. And so if we get into the issue of vacatur, if this authorization were to be vacated, that would be an extreme obstacle to this project. Investors are not going to put up $45 million, and risk their capital if there's uncertainty with respect to this project.
Wouldn't there still be uncertainty even if we remand it without vacatur?
Certainly, there would be uncertainty, but there would be a lot more uncertainty if there was a vacatur.
Okay. Thank you, Mr. Nelson.
Thank you.
I think Ms. Naismith asked for 5 minutes, so we'll give her the 5 minutes.
Thank you, Your Honor. Appreciate it. I wanted to just start by clarifying a few things with respect to the NERA data, which the department at one place does say is outdated. But one of the points that we made is if it's so outdated, then why not update it? Again, the problem with what DOE did here is to calculate these two very extreme values and then claim it could do nothing to reduce the uncertainty. If the problem is simply that the numbers are off and need to be updated, then update it. What counsels for DOE went through in terms of what the NERA study doesn't do is, again, not actually in the record and not what the climate harm assessment that DOE did either. That climate study looked at solely putting aside the qualitative data that your Judge Garcia referenced in the SEIS. If you look at the actual, where did we get these two numbers on climate, it does not look at what's going on in foreign markets. It looks at solely the extent to which displacement would occur as between Alaska and the lower 48 states. The SEIS quantitative data.
May I interrupt you? The harm that you're talking about is not a harm to any of your members, is it?
It is, Your Honor.
Well, when you don't rely on that harm for standing purposes, do you?
We rely on a variety of different harms, Your Honor, but no,
Right, well,
the
one
climate.
of them is the effect on the beluga whales in Cook Inlet, right?
Yes.
But if they wanted to, if your members are interested in assessing that, all they have to do is look at the environmental impact statement that accompanied FERC's authorization, because it's there in droves, right? Why do they need two environmental impact statements dealing with the same thing?
Well, they don't, Your Honor, and DOE here agreed, and it is not in dispute that an additional analysis needed to be done because FERC's analysis is limited by FERC's authority under the Natural Gas Act to look at the effects of the terminal and the associated infrastructure. So FERC's analysis looked at the terminal and the pipeline that would connect the terminal up to the North Slope. It did not look at the upstream effects, which we also based our standing claims
But
on.
it did look at the downstream effects. It did look at the increased shipping.
It looked at some of the increased shipping, Your Honor, but it did not look at the full extent of the downstream impacts. And that's why DOE concluded that it needed to do, and no one disputed that DOE needed to do a supplemental analysis.
The problem with dealing with the climate change as a harm for your members is that it's not imminent. No matter how you cut it, whatever would happen is 100 years away or 50 years away, correct? So you can't rely on that for standing.
Your Honor, our standing affidavits rely on concrete particularized injuries, including what will occur if the project goes forward and is both constructed and put into operation. To turn quickly, though, to the point, Judge Garcia, you were making about the analysis that was in the supplemental impact statement, environmental impact statement, that is this discussion of foreign markets. That discussion ranges through a wide set of factors and talks about how many things could point in different directions. It does not reach a conclusion. It does not say, and we think as a result of all of this quantitative discussion, where we fall in the spectrum of the two numbers that were put forth in the climate harm assessment. That conclusion is only in the order, and again, does not refer back. DOE could have said, here, let us go back and point to the SEIS and pick out all of these things. It didn't. It also didn't include things that council raised in briefing, and again today, about the findings of the overhang in the policy statement. As I mentioned earlier, DOE expressly said that's not relevant here when it was raised by petitioners in other contexts. Very quickly, the finding also in DOE, Sierra Club v. DOE being dispositive here in terms of the uncertainty being a reason to just not do anything. That in that case is distinguishable, and we make this point in our brief as to the fact that what was being disputed there is that DOE didn't include one variable, specifically whether or not renewables were being considered downstream. It did not challenge the entire approach that DOE took in that instance, which is what we are doing here. With respect to the economic
You're coming close.
My final point, with respect to the economic benefits, again, it is not in dispute that there would be some economic benefits. The question is the economic benefits that were referred to in the order and relied upon by DOE accurate? There may be benefits to the state of Alaska, but if we are dealing with 100% substitution, those benefits therefore are coming from somewhere else. They're net neutral. And therefore, what DOE should, under its standard of not simply having to say what's good for Alaska, but rather what is good for the entire US public, grapple with the fact that jobs are moving from one part of the country to another. We therefore ask this panel to remand and vacate. Thank you very much.
Thank you for your eloquent argument.
Case number 23-7076. August Cabrera et al., KEFB, Bond Intruder Next for Important Speakers, Appellant versus Islamic Republic of Iran. Ms. Konopchinsky for the appellant, Mr. McIntyre, appointed amicus curiae.
Good morning.
Good morning, Your Honor. May it please the court, Grace Konopchinsky on behalf of appellant KEFB, and I've reserved 3 minutes for rebuttal. An Iranian-sponsored terrorist attack in Afghanistan robbed KEFB of her father just 2 months before she was born. Now, the district court correctly awarded salation damages under the FSIA's private right of action to other family member plaintiffs associated with the attack, including KEFB's mother and siblings, and another victim's 2-month-old daughter. But it dismissed KEFB's claim for lack of standing, failing to distinguish between in utero children and later conceived children. This court should reverse the district court's decision for 2 reasons. First, it was inconsistent with the state court consensus that in utero children who are subsequently born alive can assert the same causes of action as already born children. Second, the district court's rationale for denying recovery, primarily to avoid a limitless class of plaintiffs that could remain open for decades, simply does not apply to plaintiffs who are conceived before an attack, and a limited, readily discernible class of plaintiffs. I'll start with the scope of the private right of action. Section 1605 AC creates a federal private right of action for US citizens for personal injury or death. And it authorizes damages which may include salation damages. Now, salation damages originally came from the wrongful death context, and they seek to compensate for 2 harms: for the grief and mental anguish from losing a family member, and for the loss of society, the loss of love, care, companionship, guidance that family members provide to each other. And this court has instructed the district courts to look to the law of the states and to general tort law in deciding what injuries are compensable under this statute. And given the use of salation and the pre-amendment history of claims that plaintiffs could bring under the pass-through approach, the most relevant causes of action are wrongful death statutes, loss of consortium claims, and intentional infliction of emotional distress.
Can I just ask you about why wrongful death statutes are relevant? And the source of my question is just the words we've used in Bettis and Frankel, which talk about common law. And as you, I think, would agree, wrongful death statutes are statutes. And so it just sort of raises a question of why we would be looking to those statutes. Could you address that?
Of course, Your Honor. So you're correct that the language used has referred to common law, but it is referring also to just the law of the states. And it so happens that because wrongful death statutes weren't recognized in England at common law, but every state has now enacted a wrongful death statute, And that is how family members are able to recover for the death of a loved one, is through that statutory claim. So I think when the court was speaking to the body of law of the states, it wasn't just referring to their common law decisions.
Can you give us any assurance that those, and you may be able to, any assurance that those two cases would have come out the same way if the courts had considered not just common law, but state statutory law as well?
Well, I think the court in Frankel said that the district court's decision in Flato was the best description of what is included within the context of salation damages. And Flato extensively discusses the wrongful death context and that history. And so the court was looking to both of those causes of action in determining what claims were compensable under the private.
Frankel's a little confused too, because it says at one point that the courts, the federal courts, have no authority to create common law, and then goes on to instruct how to find common law. And the case that they cite for the proposition that the court can't create common law was a pre-amendment case.
Correct, Your Honor.
So that's got, I mean, that's just slipped in there, and I don't know whether we ought to pay any attention to that at all. But I was thinking about to answer the question, and I've had this question too, if we're authorized to create common law, where do we look? And the usual idea of a common law is that a court without statutes gets a body of cases and it derives a principle from it and then applies that principle in the next case. And that's not necessarily what we're talking about here, because it seems to me that the only thing that's particularly clear is that Congress wanted a uniform federal cause of action, not different from state to state. And one of the ways of ensuring that is to look at everything the various states have done.
That's correct, Your Honor. I think that creating a uniform cause of action is the key point here. And so there certainly is room for dispute over whether when this court is interpreting a federal statute and creating a uniform rule of decision, do we call that federal common law or not? But for the statements in Frankel and Bettis, I'd be inclined to agree with you that that is the court creating federal common law. But there is no dispute about what the district courts are actually doing.
If I might add, I mean, before the amendment to the FISA, the court, and I sat on some of these cases, I've been around long enough to be pre-amendment, but you would look at state law, but you wouldn't look just at the state common law, you'd look at the statutes too.
Correct, Your Honor.
Before the amendment, and it seems odd to me to say that, okay, Congress amended it to make it more uniform, but now you can't look at the statutes.
Correct, Your Honor. But before 2008, when the federal private right of action was enacted, you look to the specific law of the relevant state. So whatever state the plaintiff resided in, that was the law that applied, which led to disparate recovery. It led to family members who happened to reside in Louisiana not recovering, whereas a family member whose father was killed in the exact same attack who lived in Maryland could recover. And so Congress created a federal private right of action to ensure that there was uniformity across all plaintiffs and that all plaintiffs could assert this claim under the federal private right of action. It just said, this court has said, because it didn't define what sorts of personal injuries are relevant under the statute, that it should look to those injuries that are recognizable at the common law and in state statutes. And those injuries, the death of a family member and the loss of consortium, loss of solatium, mental suffering and anguish that comes from that is certainly recognizable by all the states.
Just stepping back a little bit, do you think is it oversimplifying to say the question we should have in mind is, could a plaintiff like this recover this type of damages in most states in the country?
I don't think that's
a lot of states in the country.
I don't think that's an oversimplification at all, Your Honor. And we pointed to at least 16 jurisdictions that have held that an in utero plaintiff should be able to assert the same causes of action as an already born plaintiff in the context of the wrongful death and loss of consortium context. So I think that informs this court's decision that in utero plaintiffs are within the scope of injuries that is recognizable under the statute because their injuries are recognized by a number of the states. And then we also pointed.
What's the right denominator? Is it we're looking to all the states in the country, or we're looking to all the states in the country that have considered this question?
All the states that have considered the question, Your Honor.
Why
And
is
so
that?
here it's 100%.
And why is that the right
Well,
denominator?
because the court can't be silent on this issue. Those other 34 states haven't resolved whether an in utero plaintiff can recover or not. But here we have 100% of the states that have considered the issue have held that an in utero plaintiff should be treated the same as an already born plaintiff in terms of their ability to assert this claim, which is also reinforced by the second restatement of torts, which recognizes that in utero plaintiffs should be able to recover for torts committed while they were in utero and for the injuries that they suffer from those torts. And so the district court should have followed that rationale. Instead, the district court's rationale was flawed for
Did the restatement cover non-physical injury to the fetus?
It's primarily directed at physical injuries,
Right.
yes, Your Honor. But a number of the cases.
But where does the idea of non-physical injury come from?
So Angelini and LaRosso, two of the state court cases that we cited, as well as Anderson, a district court case from this circuit, which was the only district court case that actually allowed an in utero plaintiff to recover, all analogized to the physical tort context. And it simply, from a first principle standpoint, makes no sense to allow a plaintiff to recover for physical injuries that they suffer while they are in utero, but then deny them recovery for mental injuries and emotional injuries that they suffer because of a tort also committed while they are in utero. And that recognition has been made by
So
the
a
state court
fetus has
decisions.
rights.
The fetus has rights when they are born to assert the claim under the statute, Your Honor.
Is it I haven't looked in the Supreme Court's Dobbs case. Did they rely on any of the sort of arguments you're making here?
I don't think that Dobbs changes the outcome of this case at all. Most of the decisions that we cited.
Oh, it'd be in your favor.
Well, yes, Your Honor. To the extent that it affects the outcome, it's certainly in our favor. But I don't think it's necessary to resolve the issue. The wrongful death statutes and the recognition of the states.
Why would it be in your favor?
Because it advances an additional recognition that an in utero plaintiff should be allowed to recover and should be able to bring claims under this cause of action. But it's not necessary to resolve because she certainly was a national of the United States when she brought her claim. So we're not asking the court to rule that an in utero plaintiff is a person or a national of the United States or anything like that.
No, please go ahead, please. I was going to go very different route.
Well, me too, but I'll just go ahead. For the IIED tort in the
Correct.
restatement second in 46-2, my understanding of what district courts have said for why we should disregard the presence requirement is essentially that in terrorism cases, the tortfeasor intends to harm absent third parties. And so that's why we should get rid of the presence requirement. Is that a fair description of what they've done?
Yes, they have said that the presence requirement is not necessary because of the limitations of Section 1605 AC and the unique nature of terrorism, that it is directed not just at the original direct victim, but at their family members as well.
I'm just a little bit confused about that based on the restatement and the elements of this tort as set out there, because an intent to harm the plaintiff is always an element, right? And so then to say, well, this case is special because the defendant intended to harm the plaintiff, and so we get rid of this other element of presence, strikes me as at least a little bit odd, and I'm wondering if you have thought about that.
Right. So under 46-1, there's an intent to harm the direct victim, but under 46-2, the immediate family members of the direct victim can recover because it's presumed that a tortfeasor who is harming an individual is at least reckless to the fact that they will harm their immediate family members as well. But I will also say, Your Honor, that this isn't a claim for intentional infliction of emotional distress. Section 1605 AC is a much broader claim for personal injury, including salation damages. And so while district courts have looked to the tort of intentional infliction of emotional distress and the restatement's provisions, this court should not graft those requirements onto the statute or treat the text of the restatement as if it was the text of a statute.
Do you think we should basically just really focus on wrongful death and loss of consortium in order to rule for your client?
No, I think that
Consider the IID issue at all?
the court doesn't need to reach the presence requirement of the IID issue, certainly. And I think the wrongful death statutes provide a sufficient basis for KEFV to recover in their own right. So the court does not actually need to address the presence requirements.
My question was actually pretty connected to Judge Garcia's question. 1605AA, which begins with subsection 1, no immunity, goes to, surprisingly, the foreign state's immunity. Then 1605AC goes to the private right of action.
Correct, Your Honor.
And you say in your reply brief that any presence requirement goes to the merits, not this court's subject matter. Do you mean by that any presence requirement goes to the meaning of C rather than the meaning of A?
Correct, Your Honor. There's no question that
I
this
guess-
court has subject matter jurisdiction here.
And then I guess if that's the case, why wouldn't the same thing apply to any age requirement in C?
To any age requirement?
Right, the requirement that the district court imposed that the child be a certain age, that the child be born as opposed to unborn.
So the court dismissed her claim for lack of standing. I think it was using standing in the statutory standing sense and just making a determination that the class of plaintiffs who are born after an attack are simply outside the class of plaintiffs who are eligible to recover under the statute. It
But then it
didn't,
seems like that would be true as well for the presence requirement.
that it would address the merits of the private right of action, Your Honor.
Right. Well, no, if the presence requirement goes to merits, it seems like the age requirement goes to merits. I say that like I believe it. I'm not saying I agree with that. I'm just wondering if the presence requirement goes to the merits, why, as opposed to subject matter jurisdiction, why wouldn't the age requirement go to the merits?
Because the court didn't actually consider the text of the statute and the private right of action. It decided that the class of plaintiffs who were in utero at the time of the attack were simply outside of the relevant plaintiffs who could recover, largely for policy reasons, for concern about creating a limitless class of plaintiffs that could remain open for decades.
Do you think the presence requirement goes to the merits, but the age requirement goes to subject matter jurisdiction?
I think that, no, I'm sorry, the age I don't think either goes to subject matter jurisdiction at all. Nothing is
Then-
covered in 1605.
So
A1.
then why wouldn't we say hey, there's no immunity because of 1605 AA?
Correct, Your Honor.
And then any arguments beyond subject matter jurisdiction get forfeited by
I think the court should hold that, Your Honor, that the only
I just
thing.
wonder if there's something I'm missing. I mean, that could have been like a one sentence brief, but I'm not saying it's right. I'm just saying, looking for your help to see if I'm missing something.
I don't think you are missing anything, Your Honor. That Iran waived all of their merits arguments by not showing up to defend the judgment below. The district court dismissed KEFV's claim for lack of standing. And so the sole issue in front of this court is whether an in utero plaintiff is eligible to even attempt to state a cause of action. I think there may be some confusion over how the district court was using the term standing here.
Yeah, I'm trying not to use that term. I'm trying to
Okay.
talk about terms you use, which include subject matter jurisdiction versus merits.
Correct, Your Honor.
And I understand that Iran can't, in its absence, forfeit its immunity.
Correct.
That has to be expressly waived. But once we're past the immunity question and we're into the merits question, it seems like maybe Iran can forfeit any
Correct, Your Honor.
merits arguments.
Yes,
And if all of this case is now about an age requirement that goes to the merits, and Iran is not here arguing against your merits argument, it
correct.
seems like maybe Iran has forfeited any opposition to your merits argument.
So under section 1605A, we still have to prove our case by evidence satisfactory to the district court. And so I think the district court just held that for the class of in utero plaintiffs, we hadn't proved our case by evidence
And that
satisfactory.
would be true for the presence requirement as well.
Had the district court reached it, yes, the district
Okay.
court could have decided the merits of that issue. I see that I am well over my time.
Well, I want to make sure I understand this issue too. So I guess the way I had been thinking about it is just because of what you said, you have to make a sort of at least threshold meaningful showing
Yes, sir.
to be entitled to a default judgment. Part of that is to have a coherent theory of why you're entitled to salation damages. So if we were going to go under the IIED route, we would need to explain sort of, maybe the district court didn't mention presence, but we'd have to explain why the presence requirement isn't enforced, just like we would have to explain why the difference between a later born and already born plaintiff doesn't matter. In other words, those two questions are on the same playing field here, aren't they?
Yes, I think they both go to the question of whether KEFE can state a claim, not to the question of whether this court has subject matter jurisdiction.
Okay. Thank you.
Thank you, Your Honor.
Good morning, Your Honors, and may it please the court. I'm Thomas Birch from the University of Georgia. Today, one of my third-year students, Mr. Garfield McIntyre, will present argument on our behalf, and I'll be at council table. Thank you, Your Honors.
Welcome, Mr. McIntyre.
Thank you, Your Honor, and may it please the court. My name is Garfield McIntyre, Jr., and I'll be arguing as amicus curiae defending the district court's decision. Faced with interpreting the scope of foreign sovereign immunity, the district court chose to construe that narrowly, denying salation damages to KEFV. That decision was both reasonable and consistent with generally accepted principles of common law, and nothing KEFV has said here today warrants rejecting it. This court should affirm. I'd like to start with the discussion of the wrongful death statutes because that's where most time was spent. As Judge Garcia pointed out, it's questionable under the language of Frankel whether it's appropriate to look to the specific text of a specific state statute if we're looking to create uniformity in the first place. The exact words that the court used in Frankel were well-established statements of common law found in state reporters, the restatement of torts, and other respected treatises. So we do think that the restatement, most specifically the third and most recent restatement, is the proper source to look to. Even with respect to the state wrongful death acts.
So I guess as to, one of the things that your own helpful brief says is that in 35 states, whether through wrongful death statute or loss of consortium action, a child can recover this type of damage, right? And it seems like a straightforward way of thinking about this case is 35 states with those two, bodies of law, a child could recover, and then either every or nearly every court to have considered the question has said that a afterborn child can also recover. And so that KEFV wins. What does that sort of simple view of the case overlook?
Well, first, the 35 states that allow for loss of parental consortium do so under the text of their wrongful death acts, but the loss of consortium and salation aren't exactly the same thing. And I point back to Flatow, where the court acknowledged that there are two separate and distinct harms, as KEFV highlighted, but that the preponderant element of salation damages is mental anguish. And it's notable that it's well established that most states don't allow anyone, children, born, anyone, to recover mental anguish, specifically under the wrongful death statutes, separate from IIED claims, which I will also discuss. But on that point, if we look to, it was said 100% was the hit rate. But again, that's based upon the text of individual wrongful death statutes. So I don't think anything from those statutes, with the necessary variation they have across the country, can provide a well-established consensus. I do think that common law loss of consortiums provide a consensus showing that KEFV cannot recover. And that's because most states don't allow for parental common law-based loss of consortium claims. And the restatement notes that of the 21 jurisdictions that do, courts are roughly equally divided on whether unborn children could. So if we're looking at 9 states of 21 that even allow the claim, and that is of all states that even allow for this type of damage to be recovered in the first place, that's a minority of a minority. So I don't think that, state wrongful death statutes, whether they allow loss of parental consortium as an element of damage or the common law loss of consortium standalone action, provide a basis for
Mr.
KEFV.
McIntyre, can you tell me if this sentence is correct? In a wrongful death case about the death of a family member, I'm not talking about consortium, just wrongful death. In a wrongful death case about the death of a family member, no state court has drawn a distinction between in utero children eventually born and already born minor children.
Not in utero children, no. There hasn't been that explicit distinction made. If I could,
I'll let you add in a second. I want to see if we're on the same page about just where the case law is, and then you can tell me more about the case law. What about in an intentional infliction of emotional distress case? Has any state court drawn the distinction between an in utero child eventually born and an already born minor child?
typically the case law has not distinguished between, a conceived in utero child and a child who is not, or who is not conceived at all and would be born significantly later.
That's not my question. I'm not talking about a child that has not been conceived at all. I'm talking about a child that in a mother who's 8 months pregnant and a child who's been born for 2 months. Has any state court, let's just say this, has any state court outside of Connecticut in any case distinguished between an 8-month child in a mother who's 8 months pregnant and a child that's 2 months born, assuming the child whose mother was pregnant is eventually born?
I'm not aware of a case that made that specific distinction, Your Honor.
And I wonder, I told you I'd let you add, so I will save my next question.
The last thing that I would say about specifically those statutes is the 12 cases, not 16, that were originally cited in the opening brief, only 5 of those allow recovery for any type of emotional harm. So, I think that's really the correct number to be looking at as opposed to the 12 or today's 16. With respect to Section 869, which was discussed, and it was asked whether that could allow for mental injuries, that's certainly not well established. We wouldn't dispute that Section 869 would allow for recovery of any physical harm done to the unborn child if the child is later born alive and has a physical manifestation of that injury.
The district court talked about the problem of a potentially unlimited class. But if we limit it to children who are in utero or already born, that's not an unlimited class, is it?
No, I mean, there would necessarily be a fixed number of individuals who would be born at the latest 9 months after.
Can you think of a rational basis to distinguish in this context between a child whose mother is 8 months pregnant and a baby that's 2 months old?
Well, we think that Congress intended to create different types of damages that may be available to different types of plaintiffs depending upon their status. And for example, let's say that there had been an allegation by KEFV of an economic harm, lost income from the service member. That would be very different because their presence wouldn't be required. It wouldn't be required that she necessarily, at least under the current law, be born. There would be a lot different considerations to be made with respect to standing. Here, it is only salation damages that is at issue. And so I think that's where we have to get into can mental damages be recovered under either 869 or the IIED where the
But
plaintiff is not present?
I think that I'm not sure, I'm not sure I understand what the rational basis might be between distinguishing in this context between a child whose mother is 8 months pregnant and a child that's 2 months old. Maybe there is no rational basis to distinguish them.
Well, Your Honor, Congress certainly did not make specific findings as to, if they were going to make distinctions between, in utero versus an alive plaintiff. I can say that, because there are different types of damages available, all of which may not necessarily require the plaintiff to be alive at the time that the attack occurred, if they were in utero. Again, specifically the economic harms is the one that would most squarely fit with that it is possible that Congress could have intended to allow certain plaintiffs to get certain types of damages while not allowing others.
With solatium damages, and I understand we appointed you to argue this position, so I'm grateful to you for helping me think through these issues. With regard to solatium damages in the context of this case, if I can't find a rational basis to distinguish between a child whose mother is 8 months pregnant and a 2-month-old baby, it seems like the plaintiff here might even have an equal protection claim. If there's no rational basis for the district court to distinguish or to interpret Congress's statute to distinguish between a child whose mother is 8 months pregnant and a 2-month-old baby.
Well, to that, I'd highlight that, it's been a more recent development. I'd say that we've shifted towards, I'm going to say, widespread acceptance that, more states, in some respects, in some degrees, are allowing certain types of claims by unborn plaintiffs. And, Congress would have been aware of the legislative history at the time. But that was a different history, I think, than today, where this would have perhaps more widespread acceptance if Congress were to enact it today. I think that sort of policy would make that would be more impactful. With respect to equal protection, there are bases that Congress could have potentially considered, again, not allowing certain plaintiffs for certain reasons to recover certain types of damages, I think is the most prescient.
And the reason would have to be rational.
Yeah, and I think that it's a mix of allowing plaintiffs to recover for these types of terrorist attacks while also limiting the scope of liability. So I think there is a balance. And part of that is kind of why I think Congress also shifted towards, the uniformity approach, where under certain state statutes, you may have large or, recovery, or under certain states, you might not have the ability to recover at all.
Can I ask you about the in-presence requirement or not requirement? And I think Judge Garcia's line of questioning, is helping me understand why IIED might not be the right bucket to be thinking about anyway. I'm not saying he thinks that, but it's helped me think through that question. But just in terms of the statute itself, what Congress wrote, I mean, Congress said we want certain people to be able to recover when a foreign terrorist state has materially supported a terrorist attack. I don't understand how that could possibly include a presence requirement, because the victim is never going to be there when the material support is provided.
I think that the presence requirement arises in this case under our facts specifically because, again, and this is kind of a two-step thing, because the only harm alleged was solation, and the court has to look to the substantive theories for standing to bring a solation claim, whether it's 46-869, wrongful death acts, or common law loss of consortium, that we necessarily have to, without getting into the merits, see if there is even enough there to confer standing, specifically under 46, which is where the presence requirement comes from. So the presence requirement is implicated by virtue of solation damage being the only alleged harm and determining whether for solation damage is standing.
Congress said we want there to be solation damages, right?
Right. But
how could Congress have said we want there to be solation damages from material support, and yet we are going to require a presence requirement for solation damages when it's impossible to be present for the material support? No one will ever be present. No victim will ever be present for material support. It's not like the victim of a terrorist attack is going to be, in, the mountains, between two states and somebody hands the rocket propelled grenade to the other person. Right?
Right. I think, and I've repeated this point, but I think that because there are other types of damages that are available that don't require presence, it's not necessarily that Congress explicitly required, presence for all of these claims to be brought. And under the salation context, for example, Section 46(1), if it would have been a victim of a terrorist attack that, for example, survived, that would allow them to recover. That would be one where the presence requirement is not necessarily implicated because 46(1) doesn't have that, but it just has to be directed at the person. I think that the distinction kind of comes in where here there's a situation where because the salation damages, again, necessarily require us to look to these different theories since this court can't craft a body of common law, that presence requirement, because I would start with the initial position that we do think 46, because this court has acknowledged in upholding Frankel is indistinguishable from a claim for salation, that's the appropriate benchmark. So under 46, if presence is required and if they can't show that, we think that's the most important analog. So I first wanted to dispute the premise that state wrongful death acts were the appropriate source of law because this court has never referenced statutory law explicitly in determining or in stating what sources a district
I'm
court.
curious to hear what reasons you have for that. One reason you gave was that state wrongful death statutes necessarily are worded differently and that might be an obstacle. Is there another reason that we wouldn't look at wrongful death statutes, which essentially are defining whether somebody in KEFE's position could recover?
I do think the uniformity argument is the most powerful because specifically when Congress was intending to move away from such a varied approach, I do think that, going through the process of amending.
I'd certainly appreciate that could be important in another case, right? But if, as you say, in 35 cases, even if the statutes are all worded different, on the question we have in front of us, can a child, I'll just say, recover this type of damages? And the answer is yes. Then that seems to satisfy whatever concern we would have for uniformity.
That is assuming, of course, that the court accepts that salation and parental consortium are the same thing. And we don't think that they necessarily are. Again, because flat out distinguishes the two. And KEFE mentioned that there were two separate. I would describe those as mental anguish and loss of comfort in society as the two buckets. Flathouse stated that mental anguish was the preponderant element, but most states don't allow, again, not just children, but anyone to recover those types of damages under their wrongful death acts. So although they allow loss of parental consortium, that's not including the mental anguish that necessarily is implicated.
Is there a reason why the loss of parental consortium aspect isn't enough? It seems sort of undisputed that that's a harm that KEFE suffered.
I think that because the preponderant element is the one that KEFE cannot show, that's the one that should hold the most weight with this court. I see that I'm over time. I would ask this court to affirm the judgment of the district court. Thank you.
Thank you.
No more questions.
And I believe I reserved some time for rebuttal, but I went over my time. So with your
Okay.
permission.
We'll give you 3 minutes.
Thank you, Your Honor. I'd like to start with what is encompassed by salation damages. And this court said clearly in Frankel that it is both the mental anguish and the loss of society. And so those are the two harms that make up the element. And I think Judge Garcia was correct that you have to look to both harms. There's no question that KEFE suffered the same loss of consortium harm as a very young infant, as any child, perhaps even a greater loss of consortium claim because she has been deprived of her father's love and guidance for her entire life. And there's no question that she also suffered mental anguish. Certainly the mental anguish may be different than an older child who understands at the moment of losing a parent what has happened, but she still has that same mental anguish here. And so the court should look to both of the wrongful death and the loss of consortium and the intentional infliction of emotional distress claims in giving scope to Congress's broad private right of action for personal injury or death, including salation damages.
What year was the attack?
The attack was in 2006, Your Honor.
Can you?
I'm sorry, August 6, 2011.
In 2011, at that point, can you speak to whether KEFV was a member of the Vickers family?
Yes, she was an unborn member of the Vickers family, Your Honor.
I guess I'm asking for you to share why that's so. Not
Because
disagreeing with you.
her mother was 7 months pregnant. She was his third child that he was looking forward to welcoming into the family. I think that she is a member of his immediate family. He is her biological father. And unless the court has additional questions, the court should reverse the district court's decision that in utero plaintiffs lack standing under the FSIA's private right of action and remand for the district court to award damages.
Thank you.
Thank you, Your Honor.
Thanks. Ms. Rothenberger, can you please start his clock? We're ready when you are, Mr. Joyner.
Case number 23-7142. Junius J. Joyner III, appellant versus Morrison and Foerster LLP et al. Mr. Joyner for the appellant, Mr. Schoenberg for the appellees.
What? Yeah. Yeah. Yeah, just let it sit down a little bit.
Mr. Joyner has.
Your Honor, can you hear me?
I can hear you, although there's quite a lot of feedback.
I apologize, Your Honor. Okay, can you hear me again?
I can hear you, but There's an enormous amount of echo and feedback.
Apologies again, Your Honor. It's something I can't control. Is that any better?
That's perfect now. We can't see you, but we can hear you.
All right, thank you. I went on a little bit, but I'll start just where I began, and just to say that the case before the court, and first I'd like to reserve 2 minutes of time for rebuttal. The issue before the court today deals with, the issue before the court today is the 3 causes of action that was before the district court that dismissed. And the real issue is the pleading standard under 8A that requires only a short claim statement. And the guidance to be given for the court to consider is what's under Schweikowitz v. Saroma. And in that opinion, the court says that there's an incongruence if you're going to look at the pleading standard under, or the prima facie standard under McDonnell Douglas versus the pleading standard under 8A, which just requires a short claim statement. Under McDonnell Douglas, the plaintiff is given the benefit of summary judgment as an evidentiary standard. Pleading standard, the purpose is just to show the court that the plaintiff is entitled to prevail, or at least to not to prevail, but to offer evidence to support the claim. That's the, and in short, what the court says is that the court may only
Joyner.
dismiss it. Yes.
With regard to the pleading standard and what you are required to plausibly allege under Iqbal and Twombly, do you agree that you must plausibly allege that you were treated differently than someone similarly situated?
I completely agree with that, Your Honor, and that seems to be the respondent's main contention, is that that's something that I didn't do. And on Friday, with very short notice, the respondent gave additional supporting case law, and all those cases, they fall into 3 different categories. They fall into the first category being that basically the plaintiff pled himself out of the comparatory analysis of similarly situated. He or she also either just made conclusory statements that did not provide the factual detail, or lastly, that they didn't provide any detail at all. And the first 2 are easily dismissed because I did not, when I named the comparators, I did not plead them out. I did not name, say, like in the Redmond YMCA, that one person was a supervisor, one person was not. It was consistent across the board, and I did not make just only conclusionary statements. I included factual detail. So what's relevant to the court is under Ashcroft v. Iqbal at 129 Supreme Court, 137 pinpoint site 664, is that the determination is whether complaint states a plausible claim based on the specific context. And the court's supposed to, use its judicial experience and common sense. And if you use that standard to what I actually pled, in the case of, I'll just run through real quickly, the case of, and I don't have the benefit of seeing the clock, so I'll try to run this pretty quickly.
Mr. Joyner, you're at 3 minutes and 30 seconds, and you've reserved 2 minutes for your time. I'll give you a few extra minutes because of the technical difficulties at the beginning.
Great, thank you, sir. So with MoFo,
Mr. Joyner, can I just ask you to focus on this case? So if you are accepting that you have to plead something to show that others were treated differently from you and that they were similarly situated, what's the precise language in the complaint you would have us look to?
So the precise language is that I cited Harrison and Nolan assigned me to Rome, and it was customary for team integration team members, that being a specific word used, to be assigned to a specific team. I cited 3 specific co-workers, white co-workers, and I cited specifically that the hired counsel had hired, it's my information belief, again without discovery, had hired every single attorney, had gone strictly to a team. And so if the analogy would be, what response are asking for is something that's just unusual. To know like the background of an attorney, I would not know that. To know their title, and it's not relevant. What's relevant is that all team members were assigned to a team, and yet an African American team member was not. That would be the first issue. There's also the issue of being restricted to not go to certain areas and not be present based on a complaint of a coworker. Well, I also cite in footnote number 7 that a similar coworker went through the same thing, a non-protected white attorney, and they did not have that same restriction. The similar situated is exactly the complaint that she raised against him versus the complaint that she raised against me. I'm not going to, that information is confidential. There's no way that I could potentially have that information at the pleading stage.
Where do you get,
counsel,
Mr. Joyner, where do you get the idea that that there's a dichotomy between a protected worker and a non-protected worker? Where does that come from?
Well, that's the whole basis of being similarly situated. That's how you show the inference, the difference of discrimination by that.
McDonnell Douglas said nothing of the sort. Didn't use the word protected, non-protected. It depends on what the invidious discrimination is. A white worker is protected from discrimination, just like a black worker is. So I don't see where you get the idea that there's a difference between the two.
Well, all the case. Well, okay. So to begin with, to start with, similarly situated, specifically in the racial discrimination context, you can look to Muldrow versus City of St. Louis, the recent Supreme Court decision. That was an African American female who brought charges that she was discriminated unfairly against based on non-protected.
Yeah, before you get into other cases, let me ask you, your claim as far as the workflow or whatever it's called is based on Section 1981?
Correct.
Right. What are the terms of the contract that you're claiming was enforced illegally?
Well, actually,
let me put it different. But is there, number one, do you have a written contract? Did you have a written contract?
Okay, well, Your Honor, actually, I misstated. The original authority comes from 1901 for district treatment, but the authority comes from 42 USC 2000 A2 A1. Okay, and that's the desperate treatment. That's partly where the desperate treatment comes from. Whereas one of the things that the district court did not do was in prohibited employment context, 42 USC section 2000 E2 also has A2 language that deals with limiting and segregating employees or otherwise affecting their status as an employee. That's specifically what I claim, and there is no need for me to specifically claim, a specific theory of legal precedent, and the court didn't recognize that, and that was clearly pled, and the district court failed to bring that up.
Well, I'm looking at your complaint, and you invoke 42 USC 1981, and that's discrimination with respect to contracts. And there's a lot of case law that says that if you're not a party to a contract, you can't bring such a claim. So I'm asking you again, how do you square your complaint with the state of the law? That is that you can only bring a 1981 case if you have a contract.
Well,
What the terms of
because
the,
19
and the terms of the contract are.
Sure. 1981 bleeds into 42 USC 2000 based on the language where it says, and to the full and equal benefit of the laws and proceedings. So that is the section that brings in 42 USC 2000 E2 that deals with terms and conditions. So that's how we get there. So it's not based on a strictly make and enforce contract language.
1981 is.
Well, no, actually specific language in 1981 includes to make and enforce contracts to sue the parties to give evidence and to the full and equal benefit of all laws and proceedings.
For
So, and
for
where
the
it says
security.
enjoyed by white citizens. So the protection is that 42 USC 2000 E2 and case law shows that the benefits of working are should be equal to of a white citizen, of a protected class of an African American male like myself, and that's why it goes into other protected categories, of gender and things like that. If I can move on to higher counsel. Yes.
Mr. Joyner, you're about 4 minutes over time and about 6 minutes over the time if we had stopped when you reserved 2 minutes for rebuttal. So I am going to stop you there. I appreciate the argument and we will give you those 2 minutes on rebuttal.
Please, the court. The claim against Morrison.
Sorry, Mr. Schemberg. Mr. Joyner, could you please mute while Mr. Schemberg is speaking? Thank you. Mr. Schemberg.
Thank you, Your Honor. The claim against Morrison is that plaintiff wasn't assigned to a work stream from the very beginning of his employment, whereas others were. But the complaint provides no information about the relative qualifications and experience of those assigned to the various roles on the project, what those various roles on the project were, what a work stream is, or whether the assignments were made by the same decision maker or anything else that might justify an inference that the reason for the decision to assign him as he was is his race. In fact, plaintiff asserts in his brief that he had superior antitrust experience to the others. Maybe he did, maybe he didn't, maybe he was the only one with antitrust experience, maybe the others had different antitrust experience. Certainly the complaint doesn't provide us any of that information, but the admission does highlight that not everyone there was the same, and that therefore no reasonable inference may be made from the fact that not everyone was treated the same.
Counsel, are you familiar with our decision in Wright v. Eugene and Agnes?
I believe.
Meyer Foundation. It's a 2023 decision. It's the latest case from our court addressing a motion to dismiss under the statute.
Yes, and as I recall, that Judge Walker joined Judge Wilkins' opinion that said that the pleading, what has to be pled, tracked the McDonnell-Douglas prima facie elements.
I believe Judge Walker, well, you can clear that up, but well, let me just read something from that opinion to you. It says, I'd just love to hear how you would have us distinguish this case. Okay. Because in particular, you've drawn on cases like Butler, which is at summary judgment, and does say you need to do a lot to explain how others are similarly situated. And this decision draws on a prior one called Nanko Shipping that said allegations regarding comparators and so forth would strengthen the claim, but they're not required at the pleading stage.
I think that's right. And what I would say is that, of course, what Iqbal says is you can't just assume racial decision-making. You can't just plead enough facts to make it a possibility that there was racial decision-making. You have to provide enough facts from which the court can reasonably conclude that the defendant actually made the decision at issue because of race. You need not necessarily do that by pointing to a similarly situated comparator who was treated better.
But that is the path that the complaint in this case tried to take. And if you're going to go down that path, then you have to do more than just allege the legal conclusion of similarly situated. You do have to provide some factual information that establishes that they are in fact similarly situated. Otherwise, you just have a person saying, I'm black and they were white and we were treated differently. And that's not enough to draw the inference.
I guess the one specific sentence in the complaint is the sentence that says essentially everybody else hired through hire counsel. And I suppose in theory, everyone else hired through hire counsel for this project was placed on a work stream. And he's asking us to infer, well, if you're hired for this project by hire counsel, there's at least some determination that you have similar qualifications for the project and that's enough. What's your response to that?
Well, we don't know enough about the project to know if everybody had similar qualifications or not. Presumably, there were at least 2 roles on the project because he was assigned to something else other than a work stream, whatever a work stream might be. And there's no reason to think that it was limited to just 2 roles. And the allegation of everyone who was hired by hire counsel was assigned to a work stream doesn't address at all the possibility that others were hired through other legal recruiting firms. So I think that what we don't have is enough to say that everyone was similarly situated and that race must therefore be the explanation, or even that a reasonable inference may be drawn from that. The claim against hire counsel is that after Morrison approved his request to work remotely, that hire counsel denied the request for him to work remotely for 3 days, which he says he did so that he did not, quote, inadvertently violate a court order that coworker 1 had obtained against him. Now, ironically enough, he looks to coworker 1 here as his similarly situated comparator, but not only is the complaint silent about who granted coworker 1's request to work remotely, or even who coworker 1 worked for, which plaintiff admits he doesn't say, and he admits that in his opening brief. The complaint actually shows that plaintiff and coworker 1 were not similarly situated. First, the complaint, it includes an exhibit that shows that in the hire counsel's denial letter to him with regards to remote work, it also pointed out that his request violated a previous instruction to him that he should not have submitted that request directly to Morrison, but rather he should have submitted to hire counsel. Then it goes on to say that if he does it again, he might lose his job. And there's nothing in the record to suggest that coworker 1 had violated a similar instruction from anybody. And second, the entire premise shows a material difference. Coworker 1 had not only accused plaintiff of sexual misconduct, but filed a lawsuit against him and obtained a court order telling him to stay away from her. And so it's just simply not reasonable to assume that race, or to infer that race is the reason that plaintiff was treated.
Can we just briefly go back to Wright? Because
sure,
at least on the face of the opinion, it was a plaintiff who said she was terminated from a position and then was defamed by her employer. And it looks like the key allegation that the court credited was that her predecessor, a white man who was also separated from the company, was not defamed. And so just if those are the facts.
I don't know if those were all the facts in the case. It may be that the nature of the job was that they must have been similarly situated in ways that it's certainly not clear in this complaint that they must have been. In fact, he establishes there were at least 2 different roles here, and he says he had superior qualifications, and maybe he did and maybe he didn't. Maybe that's why he was assigned the way he was. We just don't know. A final point about the similarly situated issue, simply that in his opening brief, he says he tried to make the similarly situated argument. When that's debunked in our brief, in his reply, he comes up with a new argument that he doesn't have to make the similarly situated showing, which is true, except that he doesn't point to any other facts from which discrimination might be reasonably inferred. And his cases for the belated argument are also inapposite because they simply don't address similarly situated, or if they do it in a different context of Fair Labor Standards Act collective action certifications, or they rely on pre-Iqbal decisions. Plaintiff.
One last
Sure,
question.
of course.
Do you have a view on whether we actually have jurisdiction over the wrongful discharge claim? That's a claim under DC law, we only have supplemental jurisdiction over state law causes of action. They arise from a common nucleus of operative fact, and they really seem quite disconnected from the racial discrimination claims.
I don't have an answer for you. I'm sorry.
Okay.
I do know that the court felt that because there was no pleading with regards to dissimilar treatment, it didn't need to address the adverse action issue. But I would like to do so briefly in that plaintiff rightly cites that the Supreme Court's recent case in Muldrow provides the answer there. But that court says you have to show some kind of actual harm. And I don't think in either of these cases, situations that he does that. With regards to the work stream assignment, the only thing he pleads is that theoretically he could have lost some pay. But in fact, he pleads himself out of court because in a different paragraph, he says he cut his own pay because he was unhappy with something an associate said to him.
I want to ask you about the Wright case and the Nanco case. Wright says, quoting Nanco, the pleading standards under Section 1981 track those in the familiar McDonnell-Douglas rubric for alleging a prima facie case of purposeful employment discrimination. And the same language, that's language that's quoted from the Nanco case. But later on, in a footnote, the court in Wright says something to the effect that that in a non-disparagement, we explicitly stated that a comparator is not needed at the pleading stage, citing Nanco. And then there's an opinion by Justice Thomas in a case that I can't pronounce the name of that says that the pleading standards for, not pleading standards, but the standards for summary judgment in McDonnell-Douglas don't apply at the pleading stage.
Well,
how is it possible to square the statement in Wright and the statement in Nanco with the Supreme Court's decision in the Justice Thomas case?
I'm not sure what Justice Thomas was talking about. Of course,
He was talking about McDonnell-Douglas.
well, of course, that the difference, of course, is that the pleading stage, you have to allege the facts, whereas the summary judgment stage, you have to provide some admissible evidence to support that those facts are true. As to the statement about you don't need a comparator, again, you don't need a comparator, but if that's the path you're going to go down, then you need some facts to show that it actually is a comparator. And plaintiff, that is the path that he chose. He didn't choose any other path to go down.
The Supreme Court case is not cited in either Nanco or in Wright, but it is cited by the plaintiff here in his reply brief on page 13, I think it was. And you don't cite the case either.
I don't recall it, no.
You don't know it?
I don't think I know what case you mean, Your Honor. I'm sorry.
Let me see if I have a copy of it here. If you bear with me, maybe I can straighten this out. Yeah, here's why I can't pronounce it. It's the plaintiff or the petitioner is Swierkiewicz.
Oh, Swierkiewicz? I think that's the case. I think
Yeah.
it's an older case. I think it predates Iqbal. And
2002, yeah, it does.
I think it predates Iqbal, and I don't think it therefore provides the governing law with regards to what
Well,
the
it
plaintiff
says
has to plead.
The holding is that the McDonnell-Douglas framework is not required at the pleading.
Well, certainly the entire framework is not, because the McDonnell-Douglas framework includes burden shifting, which we don't ever get to at the pleading stage. But what we do get to in the pleading stage, and what the case that Judge Garcia referred to earlier, that Judge Walker participated in, says is that for at the 12B6 stage, what you do is you track the prima facie elements of the
You
McDonnell-Douglas
have
test.
to at least, your proposition is if you're going to make an argument on the basis of disparate treatment, right? You've got to at least allege that the people who were treated like you were similarly or unlike you were similarly situated to you.
You have to either do that or you do it a different way. You might do it through a pattern of decision-making, like a Teamsters case. You might do it through direct evidence of that, you know, I am firing you because of this.
Right.
But if you're going to compare yourself, you have to buttress that with some facts that show you were in fact similarly situated to those
The
you're
rest
comparing
of
yourself.
McDonnell Douglas, you don't have to show.
That's correct. That's correct. The burden shifting you do not have to show. I have more, but my time is up, so I look to you to add.
Your time is up. I thank you for your arguments.
Thank you, Your Honors.
Mr. Joyner had reserved 2 minutes, but I will give him 5 minutes because we went 3 minutes over with Mr. Schenberg.
Thank you, Your Honor. I'm actually familiar with Schweikowicz, and I believe it is directly relevant to this case here. The opinion that Justice Thomas is specifically talks about the incongruence between having the plaintiff have to plead a prima facie case showing an inference of discrimination versus if direct evidence of discrimination was shown during discovery, that he wouldn't have to meet that burden. And that's specifically what's going on here, and that the facts of Schweikowicz are very relevant because the court goes on to say that the pleading that the plaintiff did not plead every single detail, but he pled enough to put the defendant on notice of what the claim was. And to meet the fair notice burden, what he said was that it was broad brush strokes. The events leading up to the termination, so some of the relevant dates, the ages because there's an age discrimination case, and also with a nationality, and some of the people involved. The court said even conclusionary statements are allowed as long as you provide some type of detail. And if there's a problem, it needs to be changed based on the rule, because the language in the rule is a short, plain statement. And the only way that a court specifically says the only way a court may dismiss this is if there's no clear relief that can be granted based on the facts consistent with the complaint. I have met that burden. Yes.
Mr. Joyner, do you have thoughts on the question that Judge Garcia asked with regard to the wrongful termination claim and supplemental jurisdiction?
Your Honor, unfortunately, it was nothing that I was prepared for, so I can't answer that at this time, Your Honor.
Okay.
Mr. Joyner, one of the things opposing counsel mentioned was that the complaint doesn't allege who made decisions about placing folks on work streams. Can you explain why that sort of basic allegation shouldn't be required?
Well, I do say that I was assigned by partner Nolan and associate Harris. And the reason why that it's not relevant to actually claim those details is because at the point in time when I was hired or anybody was hired, and specifically I'd say that everyone that hired counsel assigned was put on an integration onto a specific team. It didn't matter, who actually did the administration of that. It would be similar to the lifeguard that was working for a county to go from pool to pool to pool if he's an African American, and every other white employee, as soon as they were hired, they were assigned a team. How they got assigned a team is not relevant. Again, going back to the pleading standard and going back to Schweikowicz, the plaintiff, the defendants or the response to this case, they're on notice for what that claim is. That's the whole purpose of discovery. That otherwise, like I also said in the brief, otherwise everyone has to be an investigator. It wouldn't be normal for any person to come into a place of business and get assigned or not get assigned to some particular task, and then have to try to ask the question, hey, who made this decision? Who did this? And then something happens, and you're forced to give information. There's no way that you would know. An employer looking at that situation, you're like, who is this guy? Why is he worried about that? That's not what I was hired for. I was hired to provide integration counsel for that merger. And the relevant factor is everybody on that team was an attorney. It wasn't as if there were people that were doing that I raised issue with were doing accounting or that were doing some kind of business analysis. All the attorneys that were put in that position were specifically there for the integration of these two companies. So at the point in time when I was hired, I should have been put on a team, but for partner Nolan not assigning me, and she had supervisory authority. There are a lot of issues that I wasn't able to touch on involving imputed liability, and involving the hostile environment. And I believe there's also an issue that the court should consider based on the recent St. Louis decision, where the court has changed the pleading standard or the requirement for these adverse events. I think that puts some questions to the whole idea. Okay.
Thank you, Mr. Joyner. Case is submitted.
Thank you.
Thursday, October 24th.